We want to get right to our top story, the Supreme Court decision on a major case that threatened to upend state election laws nationwide. In a 6-3 decision delivered by Chief Justice Roberts, the Supreme Court delivered a strong rejection of a fringe legal theory that had threatened to upend election laws nationwide and expand the power of state legislatures to set strict new voting rules free from state judicial oversight. We have team coverage of the decision, and I'd like to begin with senior Washington reporter Devin Dwyer. Devin, can you give us a big picture of this decision and its impact on the United States?
Yeah, a very significant opinion, Mona, and one that voting rights advocates are breathing a sigh of relief on today. This is a case, as you said, out of North Carolina that threatened to upend voting laws nationwide, all predicated on a fringe legal theory known as the independent state legislature theory. Republicans in the state of North Carolina had basically argued at the Supreme Court that state legislatures alone should get to decide the rules for when, where, and how we vote, free from any sort of check by state courts. So whatever they say goes. And the Supreme Court today, in a 7-2 decision written by Chief Justice John Roberts, fully repudiated that idea, essentially saying state courts will retain their power to serve as a check on rules that are enacted by state legislatures. This is something that's being praised now by voting rights advocates. Attorney General Eric Holder just put out a statement saying that this will protect voters nationwide, keep the courts as part of that process. And it's something that will have a major resonance now as we head into the 2024 presidential election year.
All right, we just heard Devin Dwyer say that the Supreme Court upheld the state's court's right to retain their power. But ABC News legal contributor Rasha Rangappa, what is the importance of this decision from a legal perspective?
From a legal perspective, this decision is important because it upholds a very basic jurisprudential principle of judicial review. This is the power of a court to say what the law is, for there to be checks and balances. And the independent state legislature theory was attempting to take state legislatures out of any kind of purview of the state courts. And you can imagine that if that were the case, state legislatures could go rogue when it came to election prescriptions on how elections are conducted in the state. There would be no ability to be constrained by the state constitution. What the court did was establish that there are those checks and balances within the state itself.
And I also want to bring in political director Rick Klein. Rick, what political impact could this have, specifically as we approach the 2024 presidential election?
Yeah, this takes away a potential legal tool that could be used to try to upend an election result. In fact, the Trump team tried it. They didn't get very far with it, but they tried it after the 2020 election, where they tried to get state courts to find that things that state legislatures had done in those states to change the voting laws were in violation of state constitutions and state laws. And if they had been successful in that, it could have laid the groundwork for these legislatures to go in and choose their own electors, essentially. There's also a theory out there that state legislature could simply cut out a governor or a secretary of state if they didn't feel like they interpreted the election result appropriately. What's notable here is that the Supreme Court really didn't even have to rule in this case. The court had been changed ideologically in North Carolina, meaning that the actual impact was not really going to be felt in North Carolina on redistricting. But this majority in the court decided to go there anyway. And it changes the legal landscape for 2024. It takes away one of the arrows that some Republican lawyers had in their potential quiver when it comes to litigating an election, to essentially have the legislature come in and set its own rules. That's what the court here is saying cannot happen.
All right, Rick Klein, but ABC News political contributor Sarah Isker. Sarah, what does this decision tell you about how the Supreme Court will decide on future cases? Again, as Rick mentioned, they didn't even have to weigh in.
I think that's exactly right. You're going to be hearing more from the Supreme Court when it comes to elections, heading into a very contentious election in 2024, of course. You know, this court has been characterized as a 6-3 conservative court with 6 Republican appointees. But what we've seen this term leading up to and including today is stranger alignments. This was really more of a 3-3-3 decision. 3 conservative appointees with 3 liberal appointees, something we've seen now in several other cases, including the Voting Rights Act case. And so I think we can expect the Supreme Court to weigh in more on these questions and to expect to be surprised a little bit on those alignments.
All right. And Devin, another decision today from the Supreme Court tightens the standard under which threatening speech can result in jail time. Can you give us the big picture here?
Another really interesting case came down today, Mona. It involves free speech, as you said, and threats that are made online. And as we all know, with more of us on our phones and our apps these days, those threats can be flying quickly in the Twitter sphere and elsewhere. And the Supreme Court today delivered a big win for a convicted stalker in the state of Colorado, someone who had spent 4.5 years behind bars for a series of messages that he sent to an up-and-coming singer-songwriter on Facebook. Justice Elena Kagan, in a 7-2 opinion, sided with Billy Ray Counterman, saying that the state of Colorado erred in sending him to jail without proving his intent. He always maintained he never intended to hurt anyone, never intended to threaten anyone, never intended to harm anybody. And the Supreme Court today said the standard needs to be a bit tighter. The states and others who are prosecuting for stalking and threatening messages online need to show intent, some sort of understanding on the part of the person giving the message that they know what they're doing, and potentially if they're in some sort of a reckless state, that could also count. So it's going to be tougher now for prosecutors in states to send stalkers behind bars.
And on that note, I do want to bring you in, Asha, because we heard from Devin that Billy Ray Counterman served 4 years for the messages that he sent. What do you think are the legal repercussions of this decision of the Colorado case?
Well, what the court is doing here is balancing what we have always given is a lot of protection for speech. We don't want to chill speech. That's what Justice Kagan is saying. She wants to give some breathing room, and in creating this subjective standard mental state that prosecutors have to prove, it does make it a little bit harder for prosecutors to go after threatening speech. At the same time, she says there's a hierarchy of mental states, and she does say that in this kind of case, prosecutors need only prove the lowest mental state of recklessness, that they consciously disregarded the effect of their actions. They don't have to show that it was purposeful or knowing. So it's kind of trying to toggle this balance in this new and changing landscape of social media, where these threats, as Devin said, can come very fast under different accounts, as was happening in this case.
And Sarah, before we end this, I do want to bring you in because I want to know what's your take on this case and what does it mean for women that disproportionately receive these threatening messages?
That's exactly right. You had a pretty fiery dissent from Justice Amy Coney Barrett, joined by Justice Thomas, saying that this was absurd. Of course, it should be an objective question. Would a normal person find this to be a threatening thing to do? In this case, the singer-songwriter in question had upended her life. This person had been convicted previously for threatening and assault. And so, you had a disagreement on the court. You'll have more free speech cases to come, even this term. So watch out for that disagreement between Justice Kagan and Justice Barrett.
All right, we're still waiting for other decisions, but senior Washington reporter Devin Dwyer, political director Rick Klein, ABC News political contributor Sarah Isker, and ABC News legal contributor Asha Rangappa. Thank you guys so much for that discussion.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.